What's your name?
Jeffrey Benoit.
And now, what brings you to Macon today to Secretary of State's office today?
Well, I was a former candidate in the 2014 primary race for school board superintendent in District 8, and that's it within Clayton County. As I ran for this particular seat, I've come to find out that my name was not on all the ballots as it should be. I was informed by one of the residents in Clayton County that while the three members of a family went to go and vote, the father had me on his ballot, but the daughter and the mother did not have me on their ballot. This incident was called in to me by the mother or the wife, and I immediately asked them to do two things. One is to write a statement to what had happened and then get that statement notarized. Once that was done, I got a copy of that to make sure that their statements were valid as to what they were telling me as opposed to just a complaint. Along with myself and the family, we went to the Clayton County Board of Elections that is run by Annie Bright. This issue was brought to her attention with furious and resistance from Ms. Bright. She kind of refuted it. However, it was elevated up to the Secretary of State's office in 2014. Today is March 12, 2015, so it took a while to get here. And when we got here today to address this issue, they had an agenda which most of them were dismissed. However, I was here to represent this particular complaint that it would not be dismissed. The investigator indicated that he did not get some documents as it applies to the investigation, and the documents that he stated that he didn't have, I had here, and those documents were with me. I stood before the board and simply said that this is a right that we should not take lightly, and that it does not come to me lightly, that an individual's vote has not been counted, or that the process in which an individual should be voting in his district is not correct, and that it should be corrected. However, in this particular situation, it was dismissed by the Secretary of State and the individuals on this board. So it still is a systemic problem within our community that you may be running for office, but you may not be on the ballot. This goes to why a candidate as well as the residents need to know where they live and know their address. They're two different things. Where your address is where you get your mail. Where you live is where you vote and who is on the ballot in your particular area. Do you know what school district you're in? Do you know what state representative is representing you? Do you know who your senator is and your congressman? This is where you live as opposed to your address. And before you go in there to vote, you need to know this information, because if you go to vote and these individuals are not on your ballot, then there's a problem. And they are dismissing it as a small, unseemly problem that doesn't really deserve their attention. However, it's your vote. It's your inheritance. It's what someone has died for you to have so that you can change the issues within your community. It goes to say that changes start right here at the local level. We can't change things at the Supreme Court. We can't change things at the state court. We can't even change things at the state house, but we can change the things in our community. Know where you live as opposed to your address. Know who's supposed to be on your ballot, so that when you go to vote, when these people are not on your ballot, you can stop that process right there, right at that point, and make note of that, which is why we're here today. And the Secretary of State, along with his cabinet, chose not to address it. So again, this is another opportunity for our votes to be disenfranchised, even if we are given the opportunity to vote, by virtue of not having the ballots and the individuals that are running for office in the correct place that you can make the correct decisions.
Okay, there's one thing that I want to ask you. You kept emphasizing that it didn't just happen one time. Didn't you have different years or different elections? Why did you choose to single it out? Did you do it to show that it's a pattern and practice that needs to get attention so it can be resolved in future elections? But why did you stress that so hard?
I stressed that particular issue because this has been going on since 2010. It's a systemic issue that has been known, but yet they are allowing it because all too often it's not challenged. And today I challenged it all the way from 2010 to 2012 to 2014. And with that, with the factual documents and statements from those candidates that ran in those elections, they still chose not to address it. and still choose to look at it as a very insignificant systemic issue that does not deserve their attention.
Isn't it normal under our form of government to present facts, certified documents, signed statements from the people who were actually involved? And you did that this morning, am I correct?
Absolutely. I submitted to them a certified copy of a statement signed by the family who alleged that their votes were stolen from them by virtue of not having the right ballot when they went to vote. And for that reason, given the certified documents, it still was not enough evidence, was not enough information to warrant an ongoing investigation to make a special election, to add me to a special election that is going to be upcoming in the local county election. Again, this is a certified document from the family who alleged this happened to them.
So wouldn't you think that somebody apparently may not even be concerned about the voting process if they can overlook the, you got some more letters. Explain
Absolutely.
Short form some of these other letters that you got.
Well, again, this is a certified letter from the family of the 2014 primary, who 3 went to vote together. Husband, wife, and daughter. Husband had me on his ballot. The wife and daughter had another candidate on their ballot. This goes back to 2012, where one of the candidates told the elector that she didn't get the right ballot. She didn't get the right ballot. She didn't get the right ballot. And she chose not to respond to that. But yet today, she made the statement that if we get the wrong ballot, that we just need to let the election office know. Well, she did that, and she also addressed it in a formal letter to her, and she chose not to do that. And then again, here in the 2010 election, where another individual who ran for office had the same issue. So again, 2010, 2012, 2014, we're dealing with the same county, the same systemic issues, but yet they still does not address this as an issue of concern that we need to address and we need to be aware of as a community. The Supreme Court took it upon themselves to strike down provisions of the Voting Rights Act in 2014, which took us back to 1965 when they were voted in. And now we see the systemic issue of the counties addressing issues that are changing the time that we can vote, the early voting days, and trying to do everything they can to disenfranchise the voters. And we need to be more act to act on this as opposed to respond to it.
This is the first meeting that I've come to the Ghetto Free Press in trying to get this information out. Since 2010, when I was called about the Quitman 10 plus 2 in Quitman.
Yes.
And I'm not sure if you're familiar with that case, but what happened is that the state of Georgia brought up 12 outstanding people in Brooks County.
Absolutely.
On absentee voter fraud, mishandling. Some of them had 30, some of them 30 and 40 violations. Some of them was federal, felonies. And Lula Smart, first trial was a mistrial, second mistrial, and the third, they dropped all charges against her. Then they dropped, the state of Georgia dropped all those charges against all 12 of them.
Yes.
And yet their life was put on hold for 4 years.
Yes, sir.
Are you familiar with that?
I'm familiar with that.
Okay, well, if you're familiar with that, are you astonished by what you see here today of all these dismissals? It seems like to me that somebody really do not care.
Well, it's not that they don't care. They have an agenda, and that is, it appears to be somewhat of the white supremacy agenda that's in full effect. If you look at the makeup of this board, it does not represent Georgia. Georgia has people made up of the African-American descent, the Latino descent, the Asian, and the various different descents. None of that is represented on this board.
So most people that comes in here, I don't know, I'm not white, and I'm not some of the other groups, but when I walk in as African-American, I counted all the people that are around this table.
Yes.
It's just like when most blacks, we look at 60 Minutes, or we look at 48 Hours, or we look at MSNBC every night. We look, and even the commercials on TV.
Yes.
We be looking for black children. We be
Yes.
looking for white and blacks and Latinos. We most associate all white.
Yes.
It's much like Andy Griffin show. I mean, let's face it, there was no blacks. Only one lady they said was in the background.
Absolutely.
And so if nobody speaks out, there won't be a change.
There's not going to be a change.
Excuse me, and I have white people in Atlanta, my personal friends, and they are astonished by it too and amazed by it. And so I try to tell black folk, don't be so negative among all whites, because a lot of whites want justice, they want equality, but sometimes we as black folk, we forget that.
Yes.
So I appreciate you addressing that issue. I had mentioned that, but when we look at all these people up here, we be looking for some black people. They may be black, Republican, Democrat, Green Party, Independent, but at least we ought to be at the table, because we go to Vietnam to fight in these different wars, we are represented. Go ahead, I'm sorry.
Well, I asked that very question.
What I'm going to do is be able to send you a tape, a CD, because when Ken Collins, you understand, realized he had got himself in a lot of trouble.
Yes, sir.
Ms. Cox, you know, Ballots called him up and told him, what in the world you think that you've done? What he did, he immediately, you understand, called up Lawyer Copeland. And he left a voice message on Lawyer Copeland's phone, apologizing to Lawyer Copeland and to Commissioner Maxwell, you understand, that he overstepped his bounds. But I have a copy, you understand, of that information. We will make sure that you get a CD.
Okay.
We're going to file, we're going to forward up to you, okay? So you all can listen to it, okay?
I have one other question for you. What can we expect from you and your office from this proceed? Where do we go from here? Do we wait to hear back from you?
Basically, here's what's going to happen. Of course, I'm going to do my investigation. I have to interview a lot of people. And once I get done with my investigation and it's submitted to the state election board, it will be brought up at one of their meetings, which is open to the public. Anybody that wants to come to the meeting can come to the meeting, and if they want to talk with the board and go up before the board and say something, they can do that, okay?
So we don't know when that meeting will be.
Right.
How
Yes,
long
sir.
will your investigations take?
I can't tell. I don't know how long it's going to
year?
take. I don't know. Plus, I can't tell you when it goes to exactly when it will go to the board. You know.
Now, do we have a step as far as calling the Justice Department to make sure that we have someone that's going to be at the next election or be involved if this is not done before the November 6th? I mean, in other words, how are we going to have? Because I know this investigation will take 2 or 3 months. My thing is, how can the citizens of Brooks County feel confident that there's going to be a fair election on the 11th? I mean, on November 6th. What kind of filing do we have to file to ensure that we have someone from the state or the Justice Department here? Because obviously we already know no one's trained, so we're just got the same train wreck on the 11th. So how, I mean the 6th, I keep saying 11th, on the 6th.
I can tell you this, we do go throughout the state during elections and during advanced voting where we monitor different locations. You know, that's a possibility. But I can't tell you, if you should call the Department of Justice or not. I mean, that's totally up to y'all.
But I mean, there's a problem, so how do we know, how can we rectify a problem? I mean, someone has to tell us how we can rectify this,
What I'll probably suggest doing is contact my boss, Brian Kemp's office, either by email or telephone or something, and voice your concerns. And
about someone assisting in an election.
right, I mean, I'd probably submit something to him in his office.
Mr. Arthur, in this Maxwell situation on that, I know you said you can't answer the question, but hope I can get yes or no out of you. On that situation, when that was brought to the election office, shouldn't the board as a whole should have been brought in to convene?
I can't answer that. I can't answer for an election or the county election board. I can't answer for them.
Okay. Well, just for your record, that
Right, that's part of my report.
okay, the board was not convened as a whole. I found out about it 3 days later, not from the election supervisor or the chairman of the board. I found out through concerned citizens. Mr. Maxwell called me himself, and a few other citizens have called me, telling me as a board member what was going on. But as a board member coming from the office of the election office, I was not notified of it. I was told briefly of it weeks later.
Okay.
Concerning Mr. Maxwell and that tax situation, I was a trustee with the AME Church concerning the church property that was in question. And if it hadn't been for Brother Maxwell, the church would have lost the property. He paid the taxes on it, and sent the letter to the chairman of the trustee board. They did not deal with it. And I think for him, they would have lost the property altogether. So I'm verifying that that shouldn't have been an issue. The attorney should have handled that, and they never should have came back on him. Thank God he saved the property for the church.
Have my business cards. I'll have statement forms and copies of also some of my envelopes.
What other thing? This is a copy of that DVD?
Yes, sir. I'm going to get you to release that to me.
I sure will. I'll sign with you.
Yes, sir. Yes, sir. If you would, just right up here, you said the CD copy or video copy, whatever the video copy is right here. I know it's the way that's phrased.
So I appreciate you addressing that issue. I had mentioned that, but when we look at all these people up here, we'll be looking for some black people. They may be black, Republican, Democrat, Green Party, Independent, but at least we ought to be at the table, because we go to Vietnam to fight in these different wars, we are represented. Go ahead, I'm sorry.
Well, I asked that very question. What is the process of being on this board? That this board
You sure
looks
did,
like
yes.
America.
Yes.
It looks like Georgia.
Yeah.
And they said they would get back with me. That is another way of pushing me to the side, pushing the question into file 13 or to the trash can. That's not their concern. And again, I will continue to push that issue. We need to continue to push this issue. Why? We are the taxpayers. And again, you cannot get a real true answer if you don't have a real true balance across the diaspora that represents all bodies, that comes from different segments. And again, today I don't feel that justice was done. I don't feel that my complaint was heard. I don't feel that the complaint of the citizens was heard. And again, we have to continue to be vigilant and continue to stand up and fight where we can, because my mantra is simple. We affect change where we are.
Okay, my last question to you is this. As you watched, like I did, the sheriff, I don't know him, but what do you think about that sheriff? Because personally, to me, I listened to him. I listened how he spoke about people not being trained. And the Equipment 10+2, Shaveen King, attorney for the Equipment 10+2, we had a 19-day court case. No news media was there.
Absolutely.
Not a single. I'm the only somebody that was there. So I'm going back to seem as if the voting rights is not important in Georgia. But that sheriff asked some very important questions. Some of his questions were the same Attorney Shaveen King brought out in the Equipment 10+2 case.
Well, again, he is talking about a systematic system that is set up to operate as they want it to operate, not as it should be operated. It should have been done with total anonymity to who's doing the investigation and who they are investigating. And at least you can go in there with a platform without an agenda. And it seems like we're going in there with an agenda to get the results that we're going in there with, no matter what.
Okay, I'm so sorry. I mean, I appreciate you talking. A lot of times I go to meetings, I don't have nobody to interview because these people are afraid to speak out. I'm glad you are not afraid. But with me sitting in here, I'm just looking, and all these cases are dismissed.
Absolutely.
I'm saying to myself, what is this all about?
Absolutely.
And I think might have been the sheriff. Somebody mentioned about Russia, Iran, or some of these foreign nations. We thought we was better than that. We thought we had arrived, but apparently we haven't.
Don't be a fool. No, we have not arrived. We have a lot of ways to go. You know, we are no further today than we was in 1965 when we walked the Edmund Pettus Bridge.
Wow.
No further today than we walked the Edmund Pettus Bridge. And it's ironic that I would be here today talking about this. Voting rights, the voting process as they fought for it this past Sunday, being Bloody Sunday, 50 years later. Are we making any progress? Do we care? Do we really care? Or is it just another process of just going through the motions so that we can maintain and sustain?
Are you familiar with the newly elected black mayors who they are removing from office? They got Superior Court judges moving from office. They are taking their power. They're changing governments without getting with the state of Georgia. Some of the family members on criminal trespass. I got 11 cities I have visited. And it seemed like to me the Secretary of State, the Attorney General, the governor, they all are aware of it. We've sent information to to the Attorney General Eric Holder, and yet nobody seemed to care. It seemed as if though this nation is falling apart.
It's falling apart, and I can attest to that. You know, when we look at what is going on, when we look at what's going on in our counties and cities, when we look at that, the city of St. Louis, and I hate to use that as a cliche statement, which is so highly contested in the news, but that's a very good example of where we are. And now with the investigation that's come out with the scathing reports of all the racism that's going on, that's not just St. Louis. That's not just St. Louis. It is in and about everywhere. We have it right here in Georgia. I'm dealing with some cases up I-20. They've got the same issues going on. So again, we just have to be a more vigilant people and a more committed people. We have to quit being bought out and waiting for the crumbs to fall. The crumbs don't taste that good anyway.
Okay. Once again, what's your name?
Benoit, Reverend Benoit, president of the Clayton Henry chapter of the National Action Network.
National Action Network. Other words, is that Al Sharpton's group?
That's correct.
I criticize Al Sharpton because I think Al Sharpton need to come to Georgia on these newly elected black mayors, and two white females have called me as well. It's just that people don't want change, and they want me to quit. They call me an outside agitator. But I tell them that Jesus rode into Jerusalem, and he became an outside agitator.
Absolutely.
I told him that Moses went before Pharaoh, and he was an outside agitator. I also told them that if you want your clothes clean, you better have an outside agitator put on the inside of your washing machine, because regardless of what detergent you use, your clothes will still be dirty.
Absolutely. I'm an agitator, and I do it very well.
Thank you very much.
I don't have a problem with that.
Oh, because you're with National Action Network.
National Action Network.
Thank you, my beautiful. God bless you, my brother. Yes.
Give us what you got from our break.
We're still compiling the specific issues with the assistance. We should have that very soon. I can say that we checked the statewide voter registration system, and the person who voted in his father or grandfather's place, Mr. Heyman, I believe, has never been registered to vote. So Fred Heyman's voted when he wasn't registered to vote through the error or the fault of the election people, who apparently mistook him for a family member.
Mr. Secretary, may I speak?
Yeah, hold on 1 second. So do we know why he went and tried to vote? I mean, do we know if he got the card and just thought he was registered for some reason?
I believe that's what Ms. Strong or somebody mentioned earlier. I don't remember. There have been so many people talking. I don't remember who said that he moved into his father's grandfather's house, and a precinct card had come, and so he thought he was entitled to vote, and he went. But according to the state records, he's never been registered to vote.
Okay, Ms. Sawyer.
Yes, sir. And I think Mr. Marchant made that statement as far as a registration card coming for Mr. Heyman. I did speak with my client, and Mr. Harvey is correct. I was a little confused too. But Fred R. Hammonds III had not been registered to vote in Telfair County. He did vote at the July primary. As a result of, again, the voters list just said Fred R. Hammonds. There was no distinction between the junior or senior. The person, the poll worker, just did not check the birthday.
All right, well, do we want to try to take some action here where we can until we get the rest of your report?
Well, I've still got the recommendation regarding the county and the election officials and the.
Well, do you want to go back through that again for us?
Regarding the Telfair County Board of Registrars, Rebecca Widener, Betsy Johnson, Linda Cartwright, be bound over to the AG's office.
Well, why don't you go through on the potential violations page, just go
Okay.
down through there so we can get abreast on it.
Okay.
I think we've already talked about Ms. Cornez and Ms. Williams.
Right, and then Clemens, Vaughn, Strong, Dollar are pending the review. Heyman's, I would recommend being bound over for voting while unregistered, as well as Cartwright for allowing him to vote while unregistered, and Ms. Johnson for the voter certificates, Judge Johnson for the voter certificates, and the Board of Registrars and Rebecca Widener for the failure to certify the absentee ballots, I'm sorry. Now, I would point out, and I forgot to mention, the last violation we have under them, for not rejecting the absentee ballot application without a date of birth, I think that should be dismissed. I don't think that's I think the law requires there be sufficient information to identify the voter, but there is not a specific requirement that a date of birth be present. So I would actually make a recommendation that that last count regarding Mason Spires be disregarded or dismissed.
Where is that?
It's at the very bottom under Telfair County Board of Registrars, Rebecca Widener, and it's the second charge. The first one is for 4 counts for the acceptance of the ballots, and right below it talks about the absentee ballot application of Mason Spires.
Okay. All right. Do we know if Judge Johnson's coming back?
Yes. Her attorneys.
Oh, they are. Okay. How much longer do you think it'd be before we have the other information? You know?
Can you check it down? I'll get you an estimate in just a second, sir.
Does the board want to go ahead and take any of these issues up that we can along the way? Everybody have a motion?
Mr. Chairman, I move that we bind over Fred Hammonds and Linda Cartwright, poll manager, Betty Johnson, criminal judge, election superintendent, and Telfair County Board of Registrars and Rebecca Widener. On the chart is set out for them, except with regard to the charge of accepting the elector's ballot without the date of birth, which I recommend be dismissed.
Okay. We got a motion. Do we have a second? Second. Mr. Worley seconds. Any other discussion? All right, hearing none, all in favor signify by saying aye. Aye. All opposed, same sign, and that motion carries. Thank y'all for being here today. Sorry that took so long. Mr. Harvey, do you want us to move on while we're waiting?
I would recommend we do.
Okay. All right, let me, we'll call the 2012 number 38, the Fulton County Soji case, which is, I guess, number 38 in our binder. All right, Mr. Harvey.
This is Fulton County, one of the respondents was Mr. Shoji. The board heard this case in the last meeting, and Fulton County was not noticed, so we re-noticed Fulton County. This was a case where a non-U.S. citizen, Mr. Shoji, had registered to vote. He filled out, hand-completed an application, marked that he was not a U.S. citizen. He his application was accepted by Fulton County. He was registered to vote, and he voted, I believe, 5 times in the course of about 13 years. The board dealt with Mr. Shoji last meeting. Fulton County is being cited for the violations of failing to reject the application and allowing him to vote, even though he was not properly registered, or he should not have been registered to vote. And I believe counsel for Fulton County is present. They submitted a response yesterday. I don't know if she's still here or not, but in her absence, I would submit to the board Fulton County's response regarding this issue.
What was in the response? Do you have
Briefly, they said that they say the violation associated with the alleged failure is almost 14 years old and is time barred, and then that Fulton County was required to allow him to vote because he was in the voter registration system, I think is the basis of their argument. I think she says that as far as the application goes, while the application box does have the no box check in response to the question, I'm a citizen of the United States of Georgia, there are also initials in very close proximity to the check mark. They don't have any, the employee that handled the application doesn't have any specific recollection. So I don't think that they're really denying that it maybe should have been rejected, but they're essentially saying that it happened a long time ago. And then once he was in the system, they didn't have any choice but to, and there was no reason for them to question him being in the system, so they let him vote every time he showed up to vote.
And how is it we found out about this again?
Mr. Shoji actually reported to our office. I don't remember the exact specifics of what brought him to our office, but he came and somehow learned that he was not supposed to be registered to vote, so he basically turned himself in. And for the record, I'll submit this to the board on behalf of Fulton County.
And the attorney was here earlier, correct?
I believe so, yes, sir.
I would think we might want to just hold on for a minute and see if she comes back for some reason. I'd hate to move on this and her not be able to address the board. Y'all have anything you need to add before we move on?
No, sir.
Let's go ahead and move. Do we have any other information yet on anything else? Or?
1 second, sir.
Okay.
I do have a report on the rest of the Telfair County. As far as
all right, let's we'll go back and try to deal with that where we can get these folks on the road here. Okay, go ahead.
all right, as far as Linda Clemens Floyd, she actually assisted with the ballot itself and took possession of the ballot. Patsy Vaughn took possession of 2 ballots, but did not, and I don't believe she was alleged to have assisted this. Patsy Vaughn took possession of 2 ballots. Beulah Dollar.
Let me ask you, when you say took possession, what are you saying there?
The voters are saying that she came to their house and they physically handed the ballots to her to presumably deliver. But she did not assist them in marking the ballots. And I believe that neither of those voters were disabled or handicapped.
So you're saying that would be illegal assistance?
Well, I don't think that'd be illegal possession. I think she's just cited with possession. Beulah Dollar marked 3 ballots and had possession of 4 ballots. And in addition, one of the voters, Mr. Freeman, said that he just gave her the ballot. He signed the envelope, and he didn't even vote his own ballot. He doesn't know who she voted for. Alice Strong helped fill out a ballot and transported a ballot. And then, as I think I said, Carnes and Williams both assisted only with the envelope. And I believe that covers them.
What about Martha Williams?
Only assisted with the envelope.
Okay. All right. The board have anything else? Motion?
I'll make a motion that the charges against Ms. Carnes and Ms. Williams be dismissed.
Second that.
All right, got a motion and a second to dismiss, did you say Floyd and Carnes?
Carnes and Williams.
I'm sorry, Carnes and Williams. Any other discussion? Hearing none, all in favor of dismissing those signify by saying aye. Aye. All opposed, same sign. That motion carries. Another motion.
I'll move that we bind over Ms. Floyd, Vaughn, Strong, and Dollar to the original office.
All right, we've got a motion to bind over Ms. Floyd, Ms. Vaughn, Ms. Strong, and Ms. Dollar to the Attorney General's office.
Can I ask a question?
Yes, sir.
Did we decide that you have to know whether the person possessed it to mail or possessed it to deliver before we can determine whether there's a violation?
Ms. Simpson, I said that I will be coming to the board at a future meeting with a policy recommendation on that, as well as a disposition to cases that we have received where that is an issue.
You went through the legislative history and explained it.
Well, I went basically statutory analysis of how the General Assembly chose to phrase that language.
But if you accept that explanation, wouldn't it make a difference as to whether they had it to mail or whether they had it to deliver?
It's my understanding that these questions will be resolved at a future date, and these cases will be consistent with that recommendation.
That is correct.
All right. So we've got a motion. Do we have a second?
Second.
We've got a motion and a second. Any other discussion? Hearing none. All in favor signify by saying aye. Aye. All opposed, same sign. That motion carries. All right, Mr. Harvey, that's got everybody.
Yes, sir.
All right. Thank y'all for being here today. We appreciate you showing up. Sorry it took us so long on that case. All right, we'll go back to the 2012 number 38, the Stosey case.
And Fulton County is
Oh,
present.
sorry. There we go.
And again, just to reiterate,
Okay.
the board heard this case regarding Mr. Shoji. Mr. Shoji registered to vote, indicated he was not a U.S. citizen. His application was accepted. He was registered to vote by Fulton County, and he voted multiple times before turning himself in and identifying himself as a violator. I gave the board a copy of the response you sent to me, so the board has that. That's the summary in case the board needs anything from me.
Let me just give the floor to Mr. Worley real quick.
I just wanted to say for the record that I'm recusing myself from consideration of this case.
All right, let the record reflect that Mr. Worley has recused himself and that we still do have a quorum with three members present. Okay, you want to come up and...
Good afternoon. My name is Shalonda Miller. I'm here on behalf of the Fulton County Board of Registration and Elections, Fulton County, and the department. I'm here requesting that this matter be dismissed for two reasons. One, the application at issue was submitted 14 years ago. And once the applicant was registered and showing as an eligible voter on the rolls, Fulton County did not have the discretion not to allow him to vote. I'll start with the second one just because I think that one is more summary. The statute itself, 21-590, states that it is once an elector is registered, the poll officer does not have the discretion not to allow someone on the rolls to vote. There's a Georgia Supreme Court precedent supporting that. It's all in the response that was prepared, but Briscoe v. Between Consolidation School District, which can be found at 171 Georgia 820. Once he was showing on the rolls, once he was showing on the eligible elector list, Fulton County did not have an opportunity to not permit him to vote. So we are asking that that be dismissed. Further, that statute applies to poll officers. The allegation here is against Fulton County, the Fulton County Board of Registrations and Elections. So by the plain language of the statute, it should be dismissed. Moving to the second part of the allegations with regard to the application itself. We acknowledge that an application was submitted that on the face of it, it says it was checked no, he's not a United States voter, and that he was registered to vote. We acknowledge that much. However, because this occurred 14 years ago, there is little documentary evidence that we can go back to investigate. Actually, the employee who processed it is still with the county, but she doesn't have any actual memory of processing it. All that she could provide us was what the typical process was, and that normally, and you have an affidavit there from her, Ms. Karen Ficklin, normally, she would not intentionally process someone who was not a United States citizen. Importantly, in 2001, when this happened, we didn't have any of the documentary requirements for proving citizenship. We didn't have any of the systematic checks against the driver's database or the Social Security database. So there was nothing systematically to catch it. We believe that because of the time lapse, it's severely prejudicial to Fulton County. There's no way for us to definitively say whether or not a phone call was made to follow up. At that time, like I said, there was no requirement for documentary evidence, so there might have been follow-up. But because of the 14 years that have elapsed, we don't have any way to go back and get that information. I feel like this prejudice was also compounded by the fact that there was a hearing without Fulton County present. Mr. Shoji was here, he gave testimony, but Fulton County didn't have the opportunity to examine him. Fulton County didn't get the opportunity to ask any questions, to follow up on how long he's been here, whether or not he's taken any citizenship classes. And then that quick investigation that the county was able to conduct, it looks like he's been here since 1989, owns a business here, a domestic business here, so that he might have been more familiar than what it seems with the laws of the state. Further, there is conflicting evidence in the testimony that he provided. You know, there was a statement that he voted 5 times. Then there was another statement that he voted twice. Well, the documentary evidence shows he voted 5 times. There was also some inconsistency with regard to his knowledge of whether or not he could register. I don't know that it's in your records. I can't recall offhand. But the department followed up with the Department of Driver Services to see what his license is. And his license said, you know, when he renewed his license and put on his new address, that he never registered and that he didn't want to register. So there's some discrepancy. And we're not saying that any of that it could all be memory. I mean, it's been 14 years. But there was no opportunity to follow up on any of that. time, the loss of witnesses, the loss of memory of the actual facts of the case makes it difficult to find the truth of what really happened here. And even though there's no specific statute of limitations, you know, under this code section, Title 21, typically you have a 2 to 4 year range. We are 14 years out. So we are respectfully asking that you all dismiss the charges as to Fulton County. We want to let you know that Fulton County is in the process of removing Mr. Shoji from the rolls. His challenge hearing will occur at the next regularly scheduled Board of Registration and Elections meeting. As I mentioned a little bit earlier, there are now systems in place that prevent this from happening. So even if someone checks the box or doesn't check the box, that social security number, which in fact Mr. Shoji does have a social security number, he also has a driver's license number, which is not always typical with non-citizens. But now we have systems in place. So if that happens, there's actually a verification against the Department of Driver Services. There's actually a verification against the Social Security Administration. I believe it has been addressed in the earlier part of the hearing, but the goal is to correct behavior that's inconsistent with the election laws. And here, the behavior has already been addressed. The systems are now in place that prevent this sort of thing from happening. Mr. Shoji is in the process of being removed from the voter rolls. So we request that you dismiss the county. In closing, I just want to remind everyone that the county has undergone the Board of Registrations and Elections has undergone an overhaul. We have all new board members. I think we have one board member that has remained over the last 2 years. We have a new director of our department, and we have been moving in a positive direction. Better early voting, fewer complaints. We are addressing the issues of our past, but something from 14 years ago, being able to keep pulling us back, really casts a shadow of the department and doesn't allow the department to move forward. So we are requesting that you dismiss, or alternatively, similar to what Mr. Shoji received, we're requesting a letter of instruction. I think that'd be absolutely appropriate because, as I mentioned, this has already been remediated. And it would be a way to wrap up something from 14 years ago without the need to pursue further litigation. Thank you for your time.
Thank you, Mr. Miller. Any questions for Ms. Miller? Yes. Could you repeat the code section from your comment?
590.
Thank you.
Okay, thank you. All right, no questions, thank you. Anyone else wishing to speak on this matter? Okay. The board have any questions for Mr. Harvey or? Mr. Willard, what would your thoughts be on the second part of the potential violation about that if it was registered and on the rolls, then, I mean, really the poll workers, I don't guess, would have any way to not know that as far as letting him vote?
I'll defer to Ms. Ford, but I don't believe there is any way to check unless he was somehow to disclose on his voter certificate that he was not a U.S. citizen, then a poll worker would be able to ascertain from that. But if he executed the voter certificate and turned it into him, I don't think there'd be any flags raised until he was caught in the background back office check that shows he isn't a U.S. citizen.
Mr. Harvey, did you have anything else you want to add?
No, sir.
I guess the fact of the matter, we have the original registration form.
We do.
That shows that Mr. Shoji checked no.
Correct.
Right.
Yes, sir.
You have a copy of that?
I do.
It's all.
I think it's in the packet that I provided.
Oh, it is. Mr. Harvey, you want to remind us of your recommendation or recommendations?
I don't, I'm not sure that I remember making a recommendation. I think this is a case where the board could go either way. I think there's, clearly this happened in a different time. However, it's a pretty serious oversight, and to allow somebody to vote 5 times, I don't think it would be completely out of the realm of reasonableness to issue a letter of instruction. I don't think it would be overly harsh to bind it over based on the nature of the integrity of the voter registration system. I suspect that's not helpful.
Yeah, no sense.
In view of the time constraints, this happened 14 years ago, the chances of the personnel that committed this error not being there any longer, and the issue about whether or not the poll worker would have had any discretion to not allow him to vote at this time, I would move that we issue a letter of instruction to the county.
Second.
All right, got a motion by Mr. Simpson to do a letter of instruction, a second by Ms. Sullivan. Any other discussion? Hearing none, all in favor signify by saying aye. Aye. All opposed, same sign. That motion carries. All right, the 2012 number 47, the Brooks County case number 39 up under.
Yes, sir. This is a 2012 case, and just to be clear, this case does not involve any of the allegations that have been the result of that have resulted in criminal prosecution from the 2010 election. So this is a completely different set of complaints, and I don't want people to be confused. And I also, at the outset, want to say that I got a phone call from Van Parrott, who's the attorney for Brooks County, who sent his response to the state election board and asked me to present it to you. So I'll do that at this time, if the board wants to accept his response.
Second.
I'm sorry.
Let me, we got a motion and a second to accept the document. All in favor signify by saying aye. Aye. All opposed, same sign. That motion carries.
There are several allegations in this case. One was that the elections office was not sending out absentee ballots properly and in a timely manner. That there were voters that were in the wrong district. That voters were not given privacy while voting on DREs. That election officials were acting confrontationally towards a candidate when she showed up at the election office. There was a second complaint regarding sort of the internal conduct of the board that would not be, in terms of following parliamentary procedures, it would not be something that the SEB would generally have jurisdiction over. That applications for poll workers were not being processed by the board, and that a candidate's name was left off a list of qualified candidates. We investigated and we found several problems that need to be addressed. The first was that when when an applicant would request an absentee ballot for a family member, as they're certainly allowed to do, the elections office was checking this, was attempting to verify the signature of the person requesting it. So, for example, if I were requesting an absentee ballot for my son to be sent to his college address, they were trying to verify my address, my signature on the application, and that's not required. So that was unnecessarily delaying the sending of absentee ballots, and that was a problem on the part of Brooks County. Once they were informed that that was not necessary and that was slowing the process down, they corrected that. That was brought to their attention by the original complainant. We did find that there were approximately 30 to 40 voters who were placed in their improper district and got the wrong ballots during this election. There were several complaints about the proximity of the DREs to the entry and exit point of the voting area. And eventually, Brooks County did correct that after it was brought to their attention. The allegation that the election officials acted aggressively and refused entry to a candidate, that was not substantiated exactly. A candidate came to the office to check on the issue of the absentee ballots, the one I mentioned earlier. And in trying to make sure that that candidate would not go into the voting area, they met with the candidate outside. They directed the candidate into an outer office so they could have the conversation. Apparently, another Board of Election member, Mr. Dave, Charles Dave, had a heated discussion with the candidate, and they were eventually able to conclude their business, but I don't think that amounted to a violation of the election code. The allegation regarding the Board of Elections not following parliamentary procedures was not something that the board has jurisdiction over. The complaint about a poll worker not being applied for actually ended up being a poll watcher issue and not a violation. And when the Republican Party turned in their list of qualified candidates, they inadvertently left a name off the list. The original list was posted, and then it was corrected by the party. The subsequent list was posted, and there was some concern that there was some type of malfeasance done in that. There's no evidence that there's a violation of the code on the part of the election officials. There was a complaint that election officials were told that people could only distribute absentee ballot applications if they received training from the Board of Elections. And there were several people that said they were told that by members of the Board of Elections, that they couldn't give out absentee ballot applications unless they received training. The Board of Elections says they never gave that information. Whether they did or they didn't, it's certainly not accurate information. But there's no indication that even if that happened, it would be a violation of the election code. And lastly, there was an allegation that Ken Collins, who's the elections director, had told the candidate that there was a problem with unpaid taxes and he had to be removed from the ballot. As it turned out, Mr. Collins did have a conversation with the candidate about unpaid taxes. It turns out that the taxes issue had never been adjudicated. It was not something that would have disqualified him from the ballot, and so no action was taken on behalf of Mr. Collins. So there's no violation there, even though, again, it was a case where the information that was apparently being acted on by Mr. Collins was inaccurate. At the end of all that, it's recommended that the Board of Elections staff listed in the report be bound over to the AG's office for the violation of 21-2-381 in terms of getting out the absentee ballots, placing voters in their proper districts, not providing privacy for DRE voters, and there's the last violation I think that's mentioned, I think is something that I would, hold on a second. We've got, if you look at the last page of the second to last page of the report regarding Michael Allen, the poll watcher, there was an issue where there was a voter who was voting. She was unsure whether or not she had the right ballot because she wasn't sure there was a candidate on it. She, asked him what she should do with it, and he said, you may not have the ballots you want or the candidates you want because it may be a redistricting issue. She went ahead and voted, and I think the voter's equivocation on whether or not she had the right ballot makes it difficult to sustain the violation that Michael Allen violated the election code by doing that. She didn't state emphatically that she had the wrong ballot. As far as the violation on the page above that, where we've got violations prohibiting candidates from entering polling places, I think neither of those are violations that should be sustained. 21-2-414, the candidate was going there in order to conduct legitimate business, and they ended up, to avoid an appearance of a problem, they met her outside and they were able to conduct their business outside. So I don't think they prevented her from entering a polling place. I don't think she ever intended to enter a polling place to do anything other than to conduct legal business. And lastly, on the 21-154, the certification of political party candidates, that's an obligation that is on the party and not on the election officials. And I don't think that constitutes a violation of the election code for Brooks County. So when you look at the violations page, I recommend binding over those respondents on counts 1, 2, and 3. And that on the second page, 1, 2, and then the second one he dismissed. That's it, yes, sir.
All right, any questions for Mr. Harvey? Jay?
Another question.
Yes, go ahead.
For Mr. Willard. On the number 1 violation, that's alleged violation.
Could you specify which number 1?
Yeah.
On the first page,
Okay.
the very first violation on page 1, 21-2-381, is the, I agree the law does not require that the application signature be verified in this case, but would this actually be a violation of that law?
I believe it has to be, the absentee ballot has to be sent out within 48 hours.
Okay, so that would probably be a violation of a different code section.
I think my recommendation to the board, and just to let the board know, you bind over allegations regarding conduct that you think violates the election code. And so our office to pigeonhole it into the appropriate code section or election rule, or come back to you and say it doesn't fit within one of the code sections. What you're doing by saying on page 2, 1, 2, and 1, if you elect to not bind it over, you're saying that that conduct is not something that we need to look at. Only the conduct on page 1 would be something that we need to look at. But I agree with you, the 381A1C does not prohibit the conduct that they did. It was misapplying that code section, which caused them to violate the 48-hour send-out provision.
Thank you, Mr. Miller. Just want to make sure we send it to the right format.
Mr. Worth?
I just wanted to follow up with Mr. Willard on that, because that's not the way we've done it in the past. But it seems to me that when we bind something over, we're saying that it's a violation of a particular statute, and that by doing that, we're letting the respondent know what it is that they're allegedly violating.
Except that you're putting them on notice of what conduct they have undertaken. If you don't feel that what is in this form, in terms of the investigative summary, puts them on notice that we're saying that their failure to promptly send out the absentee ballot was a violation of the election code, that's the board's prerogative, and it can determine either to re-notice the case or dismiss for lack of proper notice. But in terms of once you put that individual on notice, there are times that you bind over a case on a 385 violation that we end up actually putting in the NCO that it was a 574 violation, as being the facts are more appropriate for that code section than they may be for the 385, or adding, so that the NCO actually talks about 385 and 574.
All right, anything else, Mr. Harvey? All right, anyone else wishing to speak?
Mr. Secretary, distinguished members of the board, I am Ken Collins, the election supervisor for Brooks County. Our election office is located at 610 South Highland Road in Quitman, Georgia, 31643. I want to start off today's appearance before the board by saying that a lot of changes have taken place in Brooks County since July of 2012. As I told investigator Glenn Archie, we did make some mistakes between January and July. That the mistakes that were done without forethought, without intention, and certainly without purpose, done none the same. Since that first 6 months, we've made many strides in providing quality service to the voters of Brooks County. All the aforementioned mistakes were corrected as soon as they were pointed out to us. Measures have been implemented to avoid such errors in the future. I hate to admit it, but I have to every time. the violations named in today's ACB case outline were done. They were done because we were either too inexperienced to know any better or too dumb to ask the appropriate question to the right people to prevent us from making those mistakes. Much study has gone into the OCGA and the rules of the SEB since that time, so that those similar mistakes or mistakes anywhere close to them will not be repeated. Whenever I was hired in Brooks County in 2012 in January, I was hired into a tsunami. That was a presidential year. Not to make excuses, but to just give you some general background. It was a presidential year. For the first 45 days, I was sick and working 60-hour weeks. And wasn't going to let up. I was being coached because of the simple fact that I was brought in the middle of the first set of elections there. The March primary to the PPP was on us before we knew what was going on, but I was brought in to do that. I was also brought in at a time whenever there was a great deal of controversy in the county. And even though I wasn't a part of it, I inherited the animosities that grew out of that alleged misconduct. It has since been adjudicated, and those who were accused have been exonerated. And Brooks County is now in the process of trying to put itself back together. We have, since this time, gone through several elections where we had no problems and everything has been, corrected. And like I said, we were either too dumb to ask the appropriate questions or too inexperienced. So basically, for the first 6 months, we were, we were up to our nose in water and trying to keep it above water. Since that time, we've worked with the voters, they've worked with us, we've worked with both the Democratic and Republican parties to address issues to make it better for the voters of Brooks County, and those things have been implemented. We are constantly taking on new projects to hopefully promote the elections process in Brooks County and make it better.
Very good. Any questions for Mr. Collins? Just tell you we appreciate you and the board's efforts to keep moving things forward down there and keep up the hard work.
Thank you.
Anyone else wishing to speak on this matter? Okay. Anything to add, Mr. Harvey?
No, sir.
All right, do we have a recommendation?
A recommendation or a motion?
I'm sorry, a motion. Then we got the recommendation.
I will make a motion that on page 1 of the violations, 1, 2, and 3 be bound over to the Attorney General's office. And I believe, consistent with Mr. Harvey's recommendation, that the allegations against Brooks County Board of Elections, Chairman of the Board of Elections, Election Supervisor, with regards to 21-2-414D and 21-2-154B, that those be dismissed, as well as the allegations against the Brooks County Board of Elections, Chairman of the Board of Elections, Election Supervisor, and Assistant Poll Manager, with regards to State Election Board 183-1-12.4 be dismissed.
All right, Ms. Sullivan has a motion. Mr. Simpson seconded that. Any other discussion? I would just add again that we appreciate the work, Mr. Collins, of you and the board, and I think it is appropriate that we send it to the AG's office because it was violations, but we appreciate you being here, appreciate your honesty and the work that y'all continue to do down there, and I know that Mr. Willard will reflect that in his recommendations back to the board. So thank y'all for being here today. We got a motion and a second. Any other discussion? Hearing none. All in favor signify by saying aye. Aye. All opposed, same sign, and that motion carries. All right, we're skipping over the Floyd County case. They were not here, correct? And moving to SCB case 2012-95, which is Cook County's number 41.
This case involves a voter registration application, I won't call it a drive, but an effort at the Cook Senior Living Center. Cook County received a batch of voter registration applications from elderly voters, and some of them were marked, they were filled out with a computer, meaning they were pre-printed voter registration applications, and they were marked, some of them were marked with an X or with mark, and there was no sign of anybody signing as assisting. So Cook County reported it to us, we did an investigation, and we determined that a caseworker at the facility named Christina Hayes, whose job it was to work with residents, most of whom are elderly, to get with them and see if they wanted to register to vote and assist them with that. In their system, an X constituted a signature. So when she was completing these forms and somebody made an X mark, in her mind that was a signature, and so she didn't think she had to sign as assisting. So in the long run, she ended up submitting these voter registration applications. She assisted people in completing them. They needed assistance because they couldn't mark the form, they couldn't sign the thing, and she neglected to sign as assisting. The investigation doesn't show that there was any type of improper activity, and based on that, I believe it would not be inconsistent to issue a letter of instruction to Ms. Hayes. I believe there's an attorney present for Ms. Hayes, but that's about it.
Okay. Any questions for Mr. Harvey?
I had a question, Mr. Harvey. That particular code section applies to people who are registering to vote who are disabled or illiterate. Were any of these 11 people actually disabled?
I think they were all disabled based on the fact that they couldn't sign their names. I think that.
Okay. Anyone else wishing to speak? Yeah. Well,
my name is Tamara Branch. I'm an attorney at Reinhardt, Whitley, Summerlin, and Pittman in Clifton, Georgia, and I'm here today representing Cook Senior Living Center in Adel, Georgia, specifically their employee, Ms. Christina Hayes. All 11 voter applications were residents of Cook Senior Living Center. Regulations require that senior living centers allow residents who are able to register to vote and to exercise their right to vote. Ms. Hayes is the social services coordinator, so it's part of her job to facilitate that with them. I believe in that particular situation, it wasn't so much they couldn't sign their name as much as they don't actually have access to computers. So they were signing these online application processes, so she was gathering the information from the residents, and then she would actually fill it out for them, print it out, and allow them to sign. At some point during the registration process, it actually asked her for her name and her email address, so she did provide that, not trying to hide that she was putting the information in. They signed, and she submitted the form. She did not sign as assisting because she didn't realize that it was necessary. She now understands that it is necessary. I'm not sure if they're all disabled in the sense that the law recognizes disabled for elections, but she will sign, and we're actually revising policies at Cook Senior Living Center to ensure this does not happen again. We're interested in y'all's findings on the assistance and the possession of applications and of actual ballots, so that will assist us in our policies. But it was a mistake. It was not intentional. It was done to fulfill the federal requirements of Cook Senior Living Center. We apologize for the mistake, and we're working to ensure that will not happen again.
thank you, Ms. Grant. Any questions?
I had a question. So they actually signed their name. They did more than put an X?
I believe, we actually have not seen the applications since 2012, but Ms. Hayes believes that maybe 3 or 4 signed an X. She's not positive. She didn't make copies of them. A lot of times they either are slow in signing their signature, or they, in some cases, one person does not like how her signature looks anymore. So it's not the fact she can't write, it's just the comfort level for them. And I believe when they signed the X, Ms. Hayes notated that it was the patient's signature. So again, not trying to hide that her involvement in any way.
All right, any other questions? Thank you for being here. Mr. Tarver, you got anything else to add?
I do, if you give me 1 second to find the
I'm
file.
going to ask this, anyone else wishing to speak on this matter? Okay.
In some cases they did sign, but in some cases.
The issue is about the signing as assistant, correct?
Correct.
All right, any other questions for Mr. Harvey from the board? I'm ready for a recommendation or a motion.
I'll make a motion with a letter of instruction be issued in this case.
Okay.
Second.
All right, we got a motion for a letter of instruction and a second. Any other discussion? Hearing none, all in favor signify by saying aye. Aye. All opposed, same sign. That motion has carried, and we'll move to SEB case 2012 number 98, which is Long County number 42.
This is a case that actually involved 3 elections. July 30th, 2012, March 12th, 2013, and June 18th, 2013. There were multiple allegations, including UACAVA ballots not being delivered, candidates being at polling places, electors being in the wrong district, problems with public tabulation, correspondence not being sent regarding ballots, convicted felons voting, not all vote totals were properly gathered, etc. In the course of our investigation, we found multiple violations. We did find that a candidate, Janet Watford, entered a polling place while she was transporting a voter to vote. She'd driven a voter up to vote. The voter was taking a while. She went inside the polling place and waited while the voter voted. We had 2 voters, Roger and Margaret Houston, placed in the wrong districts. Alton Cummings Jr. voted while serving a felony sentence. The Long County Election Office failed to notify a challenged voter of their status and rights of appeal. Long County failed to keep a complete absentee ballot log for the July 31st general primary. Long County failed to print the election office return address on absentee ballot return envelopes for at least 3 electors. Long County failed to document receipt of absentee ballots from 4 electors. Copies of DRE tapes were not filed with the clerk of Superior Court. Long County challenged 2 electors and determined they should be removed, but then failed to remove them from the electors list. So there was a long list of kind of persistent problems that went on in this election. And I recommend that Long County and Vanessa Cunningham be bound over to the AG's office for the listed violations. Alton Cummings should be bound over for attempting to register and vote while serving a felony sentence. Janet Watford, who is a candidate who entered a polling place while waiting for somebody else to vote, I think is one that is a candidate for a letter of instruction. There was no allegation that she was doing any type of campaigning while she was there, and she was there transporting a vote.
All right, any questions for Mr. Harvey? Anyone else wishing to speak?
Yes, my name is Janet Watford, and my address is 99 Powerline Road, Northeast, Little Vista, Georgia, 31316. And Mr. Secretary and Board, I'm privileged to be able to speak before you today. I just want to tell you my version, and I appreciate the letter of instruction but my version was just a little different. Says during the early voting period, the 2012 primary election, I was approached by an individual named Dora Candy. I've known Miss Candy since she was in high school. While conversing with her, she requested a ride to the courthouse so she could vote, and I was happy to assist. In addition to serving as the polling place for Precinct 4, the Long County Courthouse is home to almost all governmental functions in Long County. These include the Board of Elections, Registration, Planning and Zoning, State Court, Probate Court, Magistrate Court, Superior Court, Licensing, Land, Records, and the Board of Commissioners. Excuse me. The courthouse is also within 150 feet and shares the same parking lot with the Sheriff's Office, the Tax Assessor's Office, and the Tax Commissioner's Office. Additionally, within 150 feet is the Office of the Board of Education, of which I'm a member. At no time during the drive from Miss Candy's apartment complex to the courthouse did the two of us discuss anything regarding the election. When we arrived at the courthouse, Miss Candy went inside and I waited in my truck. However, it was a hot day, and I soon became concerned that my truck would overheat. I turned my truck off and went inside in the lobby of the courthouse. At no time did I enter the actual polling place where the machines were set up and the business of the election was being conducted. Within minutes of entering the courthouse, I was approached by Vanessa Cunningham, the election superintendent, and she informed me I was breaking the law and I had to leave. I immediately left. From the time I left my truck until approached by Miss Cunningham, only 2 or 3 minutes had elapsed. At no time while in the courthouse did I discuss the election or my candidacy with any individual. I knew then it was not permissible for anyone, including candidates, to campaign within 150 feet of the outer edge of a building containing a polling place. I ran in my first election in 1992 and the same law was in place then. It was not and is not my interpretation that the mere physical presence of a candidate constitutes a violation. But if my actions and our interpretations are in error, I certainly want to apologize. It has not been my intent to violate the law or be perceived as doing so. My sole purpose for being at the Long County Courthouse that day was to assist a friend and get out of the South Georgia heat.
Thank you, Ms. Watford. Any questions? I have one question. So you were on the ballot at the time, correct?
Yes.
Did you have opposition?
Yes.
Okay. All right, thank you. That's all I had. Anybody else? Thank you for being here.
For the record, my name is Jeffrey L. Arnold. My address is P.O. Box 339, Hinesville.
Can you give us your last name again?
Arnold, A-R-N-O-L-D. P.O. Box 339, Hinesville, Georgia. And I think I'm number 10 in the report, but I escaped scrutiny. I want to first say that Mr. Harvey was very much a gentleman, very cooperative. I represent Ms. Watford as well as I'm a state court judge for Long County. And my primary reason is not to embellish upon or add to what she said. I'm more concerned about just understanding it, because during this period of time, I'm holding state court upstairs and walking back and forth across the area. For those of you not familiar with Long County Courthouse, it is fairly small, like most South Georgia courthouses. And the voting machines are in 2 separate secured closed rooms. The hallway she's talking about, oftentimes the people identifying who you are, that they sit out there, okay? But the people are walking back and forth. And so I guess what I'm asking, just for clarification, because I've tried to find in the law, I've tried to find an AG opinion as to what constitutes a polling place, especially in a situation like we have, where they're using the courthouse, and the courthouse is not exclusive to the voting. And I do want to underscore that the voting machines were secure, and they were in 2 separate rooms, but the rest of the courthouse was open, you had access to. Thank you very much.
Okay. Thank you for being here, Judge. Any questions for the...
And I want to be back here again.
All right, anyone else wishing to speak on this matter? Okay. Mr. Harvey, did you have anything you wanted to add?
No, sir. I think to the judge's question about what he's allowed, I think that the board and the law allows, prohibiting entering a polling place except to conduct business. And I think the board generally recognizes if somebody is conducting business, if you have to go in to pay your water bill, my experience is that most candidates would make every effort to maybe have somebody else go in to do it to avoid the appearance of it. Obviously, if you're the presiding judge, you can't send somebody in your place. And I think the board recognizes that if a complaint were to be made, somebody were to say that, the law specifically allows probate judges who might be allowed to conduct their business. So I think by extension, without taking Mr. Willard's place at the AG's office, I think that other judges would certainly be given that same consideration.
Okay, anyone else wishing to speak?
I have a question for Mr. Harvey.
Ms. Sullivan.
The way that our violation is written for Ms. Watford, it states that she violated 21-2-414 and that she was within 150 feet of a polling precinct. I just want to clarify, is it an accurate state to state that a candidate is prohibited from physically entering the polling place and is campaigning within 150 feet?
That's correct.
Is that accurate?
Yes, ma'am. You're correct. If we have the citation. Because I think the 414 is prohibiting on the campaigning.
So you can be within 150 feet as long as you're not campaigning.
Right, but candidate cannot enter the polling place. That's my understanding.
Well, that's paragraph D of 414 says no person whose name appears as a candidate except a judge of probate court shall physically enter any polling place other than the polling place at which a person is authorized to cast his or her ballot. So it is 414D that would prohibit Ms. Watford from entering a polling place.
But Mr. Harvey, if this was, she took someone there to do early voting, right? Ms. Watford?
Yes, sir.
Ms. Watford would have been allowed to vote in that.
Ms. Watford would have been allowed to vote.
Yeah. So she would have been allowed, it says shall physically enter any polling place other than the polling place in which the person is authorized to cast his or her ballot for that primary. Well, she would have been authorized to cast her ballot in the early voting location.
Additionally, I want to make it clear
Okay.
that the voting machines are away, so what constitutes a polling place? That's all I'm asking.
I think, Judge, I think that's the point. Hanging stuff is when you have a multi-purpose, multi-use building, where's the polling place? I mean, if the voting machine's on the first floor of the courthouse, there's an elevator on an outside entrance, and you go up to the courtroom on the second floor, like you would do in Tifton, if our voting machines go down in the basement or on the first floor, you go to the courtroom and you'd be in the courthouse, which that you wouldn't be anywhere near with the actual voting machines on. So is the polling place where the machines are? I think that's your question.
Yes, sir. That's her question too.
Mr. Harvey, so the complainants in this case, what were they, what was their issue with this?
The complaint regarding Mrs. Watford was that she was in the polling place while she was a candidate on the ballot. That was the...
So who made that complaint? Was it Reddish, Middleton, Smith?
I would have to, let's see.
Ms. Walker, you just said the election superintendent came and told you you couldn't be there and asked you to leave and you left, correct? And who was that?
Vanessa Cunningham.
Okay, that was.
It was Marla Reddish was the complainant regarding Ms. Watford.
Mr. Chairman?
One of the red issues, the daughter of who she was running against.
That's what I was trying to get to. I knew there had to be something else going on here. All right,
But we were trying to stay away from personalities.
you gotta get it out there, Judge. We hear it all. We hear it all.
This is all day, and I was just trying to avoid
And
that.
we listen to it all too, so that's good to know. Are any of the complainants here? All right, that's good to know too. Mr. Harvey, I'm sorry, Mr. Willard, were you gonna interject?
I was just gonna ask, Ms. Watler, you had already voted when you had not voted yet. Okay.
I could have voted that day. All I was caring about was the heat. You know, I'm 68 years old.
I understand, I appreciate that.
You weren't still trying to make up your mind who you were gonna vote for in the vote for education race.
If we had enough time, I could answer that. I actually ran twice for the same office.
All right, does anybody else have any questions? So the recommendations, again, Mr. Harvey, were to bind over the Board of Elections and Registration, Ms. Cunningham, the superintendent or chairperson, and then Mr. Cummings for being a felon.
Yes, sir.
Right, and then, of course, the issue with Ms. Watford. I'm ready to take some motions if y'all got any.
Well, I would make a motion that we dismiss the charge against Ms. Watford.
Got a motion by Mr. Worley, got a second?
Second.
Second by Mr. Simpson. Any other discussion? Hearing none, all in favor signify by saying aye. Aye. All opposed, same sign. That motion carries and we've dismissed that, so thank y'all for being here.
Thank you very much.
Thank you. I didn't want to be 68 and get my first
You're all right. Okay, that's got one of them. Do we have a motion or for the remaining respondents?
I'll move that for Long County Board of Elections and Registration, chairperson, Ms. Cunningham, be bound over with regard to the listed violations, as well as Mr. Cummings.
All right, got a recommendation to bind over the three remaining respondents. Do we have a second?
Second.
Got a second by Mr. Worley. Any other discussion? Ms. Ford, I had one question. I don't know if you know this or not, but do you know if the Long County election superintendent or their folks were at the training on February 27th in Hinesville?
No, they were not.
They were
Vanessa
not.
Cunningham is no longer with Long County,
Okay.
but the people who are with Long County were not.
So the new group didn't show up to the training right in their own backyard. It's good to know too. All right, we got a motion and a second. Any other discussion? Hearing none, all in favor signify by saying aye. Aye. All opposed, same sign, and that motion carries. All right, Mr. Harvey, we got 2012-101 City of Ludowici.
This case is, might be a little bit similar to the previous case in Ludowici with the alcohol referendum. The issue here is that a city council member resigned to run for another office, and citizens wanted, the city charter was unclear as to when an election had to take place. An election was delayed, the election wasn't called for. There was federal litigation going on with the Justice Department and districting and issues with the city, and so an election wasn't held to replace this city council person. Eventually, the complainant in this case filed a writ of mandamus that was issued by a judge. The judge ordered the city election, and the election was held. Based on all that, I recommend that the State Election Board consider dismissing this case. It's been resolved, and it's frankly just a very convoluted legal mess as to everything that preceded it. I'm not sure it's worth the board's time.
All right, any questions for Mr. Harvey? Hearing none, anyone wishing to speak on this case, we have a recommendation of dismissal. Yes, ma'am.
Good afternoon, Chairman and board members. Cindy McClellan, 380 South Main Street, Ludowici, Georgia. I serve in the capacity as the city registrar. and currently being trained to be the election superintendent for the upcoming election. We followed the advice of the Board of Elections, Vanessa Cunningham, on we need to be redistricted, that we were in violation of the Voting Rights Act, where our districts were not reapportioned right. Excuse me. And we went by her recommendation to hold off till we did the redistricting of the election.
Are you in support of the dismissal
Yes, sir.
recommendation?
Yes, sir.
Just wanted to make sure you didn't want us to do something.
I just want to point out that that's why.
No, thank you very much. We appreciate you sticking around. Any questions for Ms. McClellan? Okay, thank you. Well,
Thank you.
Good luck in your new role. Anyone else wishing to speak on this matter? Hearing none, do we have a motion to dismiss?
So moved.
Mr. Simpson moves. Do we have a second? Ms. Sullivan seconds for dismissal. Any other discussion? Hearing none, all in favor signify by saying aye. Aye. All opposed, same sign.
No.
Mr. Worley votes no, and that motion carries to be dismissed. All right, Mr. Harvey, 2012, number 104.
This case involves Jefferson County. In 2012, initially, Jefferson County election officials were rejecting absentee ballot applications that were sent to them because there was no reason given on the application. As you know, there's no reason, you don't have to specify a reason to request an absentee ballot. When this was brought to their attention, they corrected this. They contacted all the voters, got them their absentee ballots. All the voters were able to vote absentee ballots. There was one case where an elector named Ricky Walden voted in person, and he voted for an old address and did not complete a change of address form after moving. The poll officials did not require him to change his address form as they should have. So the violation was improper rejection of absentee ballots, which was corrected before any damage was done, and one person failing to complete a change of address form when he voted from an old address. Based on that, I would make a recommendation that Jefferson County and the poll workers be issued a letter of instruction. Jefferson County is now clear on the process for receiving absentee ballot applications, and I think a letter of instruction is an appropriate resolution in this case.
Any questions for Mr. Harvey? Hearing none. Anyone else wishing to speak? Yes, ma'am.
Hello, my name is Susan Gray from Jefferson County. I serve as election superintendent. My address is 415 Green Street, Louisville, Georgia, 30434. I just wanted to come before you, Mr. Chairman, and all distinguished members of the board, and just say that there was no intent for us to keep anyone from voting, and we had little experience in the voter registration side. In July of 2011, Jefferson County went to a combined board, and at that time, the current registrar became election superintendent. And I worked with the probate judge, which was also the election superintendent. In January, the registrar resigned, the current election supervisors resigned, and then I took the job in January 2012 as the election supervisor. With little experience on the voter registration side, I would just like to ask the board to or just let the board know that we had no intent of breaking the laws. And just thanks for letting me speak today.
No, thank you for being here, and we appreciate your honesty and appreciate the efforts you're making to get up to speed on everything. If we can help you in our office, I hope you'll let us know. Did anybody have a question for Ms. Frank? Okay, no questions. Anyone else wishing to speak? We have a recommendation for a letter of instruction. Do we have a motion? Got a motion by Mr. Worley to issue a letter. Do we have a second? Second by Mr. Simpson. Any other discussion? Hearing none, all in favor signify by saying aye. Aye. All opposed, same sign. That motion carries. Nobody here from Montgomery County, correct? All right, moving to Dooley County, 2012 number 119.
The allegation in this case, with several allegations, most seriously that the DRE machines were unsecured and unattended in the election office. There was also an allegation that the LNA testing was not properly advertised and conducted. Our findings revealed that the DREs were left unattended for a short period of time, approximately 10 minutes, on occasion when a supervisor had to leave the office. This is before voting. A supervisor had to leave the office to take care of personal matters. LNA testing was advertised a week after LNA testing started. So that's a violation and failure to notify the public of LNA testing. The other allegations were unsubstantiated, and at this point, we're left with a very brief period of unattended DREs and a week late advertising of LNA testing. And I believe somebody's here from Dooley County.
Any questions for Mr. Harvey? Okay, hearing none. Anyone else wishing to speak?
I'm Bert Gregory. I'm the county attorney for Dooley County. I reside at 305 East Union Street in Vienna, Georgia. We have, Bernetta Cheney Childs is with me, and she is our elections supervisor. And Ms. Childs developed the elections office when we went out of the probate court after our longstanding probate judge was removed or encouraged to be removed by the JQC for punching out a deputy that was there to assist during a tornado. And we won't get into all that because there was a trial on it. But that set in motion some stuff in Dooley County. And when he resigned and we had a new probate judge, this office was set up and it was separate and moved from the courthouse to a building that has an adult education component and maybe an economic development office. There's about 3 separate small offices that have 1 or 2 employees in it and a classroom. And it's handicap accessible and it's easy enough to get to. So that was the location we chose. At that time, there was 1 room that was allocated for Ms. Child, and she was given the assistance of a part-time employee. That is what led to these problems. But since then, I won't point out the remedial measures that are in place that have corrected that. Number one, once the budget was allowed it, we have now upgraded to a full-time assistant to her, who now has an outer office with a separate office for the counting and for the machines, and then her office, both of which have locked doors. So the problem will probably never happen again because we now have the office up and running appropriately, fully staffed, and fully funded as far as the renovations go. So we think that'll take care of the issue of her leaving unattended for a moment to go to the restroom when her part-time employee was not there. You also need to understand that the genesis of this complaint was during, pretty much during the early voting session as far as the locked door or the unlocked door went. I believe that was on the 18th of October of 2012. On the 17th of October of 2012, the day before, the same person who made this complaint complained that during the lunch hour, one of the other entrances to the building was locked off because it had an office component to it. And so they called the state fire marshal because we had a locked door. And we had to go down during the lunch hour and post an exit sign on another exit to satisfy that complaint. Then the next day, your complaint comes about an unlocked door for a few minutes. So we have a lot of technical complaints. We think we're in compliance now. We admit that we were not technically in compliance then, but we would ask that the board consider a dismissal as to those. As to the notice in the paper, Vienna or Dooley County has one newspaper that is a weekly paper. It's part of a group of other papers, and so it shares a roving reporter with some other counties and has a part-time person that attends that office. During 2012, the person who's in that office would not regularly attend that office, and it resulted in, on the Superior Court clerk side, having grand jury notices of the proceedings not being published, even though those had been submitted. It resulted in my personal law practice with an adoption, where you have to run a certain notice and length on termination and so forth, very time critical. They just they didn't run it. So in both of those instances, much like in this instance, the notice was submitted timely and directed as to when it should run. And then the paper on its own initiative chose not to put it in the paper until the next cycle, which creates all kinds of problems when you have technical timing requirements. And so since then, I think they've changed an employee at the paper. That's beyond our control. What remedial action that Ms. Jane Childs took when she realized that it had not run in the paper was to post a notice, and I'll let her explain where she posted that notice.
Bernetta Childs, 501 North 3rd Street, Vienna, Georgia, 31092. Once I realized that she hadn't published the notice, I made copies and I published a copy of it at the office I work in, and I also published a copy at the courthouse. And I just want to add that all these allegations that he have on us came because a candidate failed to do the proper paperwork to have his name on the ballot. So he set out to do any and everything he could to get me in trouble. But I did make an effort to publish the paper in a timely manner. It did not happen though. So I did the next thing I knew to do, and I just published it at the office in the courthouse.
I participated in the early voting at this one location where they had the early voting. And at the time, there was a gentleman who was seated on the floor with a backpack. And my uncle is on the Board of Elections, and he was in the hallway, kind of monitoring the situation. And I walked by and said, "What are you doing?" And he said, "This guy's been here all week." And this is the guy who sat there all week, Mr. Potter. Mr. Potter and his wife were suing Dooley County because their house burned down while they were out of town, and they lived on a rural road with no neighbors, and they say that we should put the fire out. So that's what we're dealing with, folks. And I know it's local color, a little local flavor for things, but I don't think any of these allegations meet. I mean, none of these allegations state that any voter was disenfranchised, and there's no complaint of any particular voter other than what came through the poll watcher who was on the campaign staff of Mr. Williams, who was running for sheriff, who incidentally is now running again for sheriff in a special election to be held on Tuesday.
And I also want to add that once I did leave the office and he did make notice of it, I checked the seals and made sure that they hadn't been tampered with. And I also told my poll workers that they make sure that the zero report showed 0 counts for every last one of the candidates, which it did.
All right, any questions for Ms. Childs or the counselor? All right, let me just say I appreciate y'all being here and explaining all of this. I hope you can appreciate the process, the transparency of having a notice on testing. That's a very important part of our voting system to assure the public of, we have a transparent process, that this is done before the election to make sure that we have a secure election, and also obviously not leaving the machines unattended. I certainly understand the circumstances you're in, but I think it's important to know that these things are very important to keep the public's integrity on our system. So whatever you can do to help us with that in the future, that's very important.
Ray, can I add that this did happen, but the time frame when I did leave to go to the restaurant, it was after 5 o'clock. I was in the process of going to the restaurant, and at the time, it's only 2 ladies that be in the building. And as a courtesy to one another, we always let one know, okay, you're in the building by yourself. On my way back to my office, I stopped and let her know that, and we did chit-chat for a few minutes. And he was there by the time I got down there. Normally, we would have already locked the door, so he wouldn't even been allowed to even get in the building. But I was getting ready to head out at that time, so I was waiting until I got in.
The point of it is we've made remedial measures and implemented policies so that the office is not unattended, and if it is, if both she and her assistant are gone, the door is locked. Right. And that creates that issue. And also on the newspaper issue, this was her third election, I believe, and she had had no problem with the newspaper before, but now that she's had that problem, just like my assistant has been instructed, is until you hound them until you know what's in there. And it's frustrating when you think you can trust the newspaper to put something in and they don't do it.
No, I could imagine. Okay, any other questions? Okay, thank you. Anyone else wishing to speak? Mr. Harvey, what were we recommending?
I think this is a case that would be appropriate to consider a letter of instruction. As far as the notice to the paper, in the report, and I have to say, it appears that Ms. Cheney Childs was very responsive to our investigator and provided as much information as she could. She said that she sent the LNA notice, but the paper did not receive it. I must have deleted it when it didn't go. I'm not exactly sure what that means, but in any event, I think if it was a technical email issue on her part, or something with the paper, I think that the fact that they're in a new building is probably speaks towards a letter of instruction for issues that they probably have outgrown with new facilities.
Brett, can I explain
Yes.
what I meant?
Yes, ma'am.
When he said I had deleted something, when the investigator asked me to show him the email, that's what I was talking about.
Okay.
The email is deleted.
So in other words, you're saying you sent the email,
Yeah,
but you didn't save a copy of it.
Okay. All right. Anybody else wishing to speak? Hearing none, do we have a motion?
Mr. Chair, I'd make a motion that the suggested violation relating to the newspaper publication be dismissed, and that a little instruction be sent on the other two proposed violations.
Second.
All right, we got a motion and a second for a letter of instruction, except for the newspaper issue in a second. Any other discussion? Hearing none, all in favor signify by saying aye.
Aye.
Aye. All opposed, same sign. That motion carries. All right, let the record show that Ms. Sullivan needs to step out for just a minute. We still have a quorum of 3 remaining members. All right, Mr. Harvey, 2012, number 128, Stewart County.
This case involves absentee ballots. Our office received a sort of bizarre complaint about somebody a candidate allegedly possessing absentee ballots. So we looked into the absentee ballot issue, and we found that Stewart County, as a practice, had problem accepting absentee ballots or rejecting absentee ballots that didn't have proper addresses. One of the requirements for returning an absentee ballot is a signature and an address on the return envelope. We found that there were 50 cases where people returned absentee ballot envelopes, their own absentee ballot envelopes, and they didn't have either their residential address or their complete residential address, and those were accepted by Stewart County. There's a single incident where an elector, Carol Iverson, retrieved, mailed, and failed to sign the oath of assisting on 2 absentee ballots that belonged to non-related friends. So we've got Stewart County cited for failing to reject absentee ballots, and we've got 1 voter cited for 2 counts of possession of absentee ballots. I spoke with somebody from Stewart County yesterday, the day before. She indicated that they were this time they were in the process of going through a 911 address reorganization, and they weren't aware of what they had, how they had to distinguish between a residential address and a PO box.
Okay. Any questions, Mr. Harvey? Anyone else wishing to address us?
Mr. Secretary, thank you, ladies and gentlemen of the board. My name is Franklin Coleman. My address being 212 North Westover Boulevard, Albany, Georgia, 31707. And I'm with the law firm Perry & Walters. We represent Stewart County. I'm here today on behalf of the County Board of Elections, Election Supervisor Diane Powell, and Ms. Bennett, Mary Ann Bennett, who's also named here. We don't have any affiliation with the other party, Carolyn Iverson. But what we'd like to request that the board consider a letter of instruction. It's acknowledged that the 49 or 50 ballots with P.O. Box, incomplete addresses, etc., were accepted. I don't have the exact numbers here. I haven't been through them specifically one by one to tell you how many had a P.O. Box, how many had an incomplete address, etc. But what Mr. Harvey said about the 911 reorganization or realign, that was the initiation of the E911 service around that time, and it wasn't exactly. It had been done prior to the 2012 election, but not much prior. And that would have been the first time that many people had a street address number at all in Stewart County. I mean, a great many of these homes. So they would have been able to, nonetheless, I mean, they could have put a location or a street name on their application or on their return envelope, but you know, most everybody there at that time, and really to a large extent now, receive their mail in a P.O. box. And so that's just one of those rural county things that it seems to be pretty frequent in those type of places. Nonetheless, we acknowledge that it was violation. We're taking measures to correct it. I've spoken with the chief election supervisor, and situation's been remedied. We hope that we won't have any similar problems in the future. So we just ask that the board consider a letter of instruction.
All right, any questions for Mr. Coleman? Mr. Coleman, I'd ask a quick question.
Yeah.
You say this situation's been remedied or in the process of, do you know exactly like how they're doing that?
Well, they were computerizing everything. You know, this is, I believe, again, I haven't been through every little piece of evidence on this yet. I mean, hopefully, I was hoping not to have to. But I believe at the time that, you know, most of these voter registration lists were all on one system or on a primitive type system or even handwritten. You know, they've computerized everything now that in hopes of just better organization, but mostly just making everybody aware, poll workers and, you know, whoever else is working at the elections office that we gotta have, you know, a street address.
Okay.
And it has to be, you know, signed, complete, just sending everybody to training to make sure. I believe that now that I think about it, I can get you that information, but she had indicated that they were all, that the poll workers and other personnel would be attending training.
Ms. Ford, have they been coming to the training, do you know?
I believe that they have been to my training, not the poll workers, but.
Right. Well,
Okay. All right, thank you. Any other questions? Mr. Worley?
I have a question for Mr. Harvey.
Yes, sir.
Mr. Harvey, if these 49 or 50 absentee ballots, how many provided no residence address at all? It says some only provided a P.O. box, others only provided a partial address.
I don't know that I'll be able to give you an absolutely precise answer, but give me 1 second.
The lengthier report does say that 40 of the absentee ballots had a P.O. box, and then 10 were either partial or no residency.
that's good enough. So that, to my mind, that's consistent with what Mr. Clayton says about the changeover. That people were,
I
we didn't
agree.
have a street address, we're using the PO box that they previously.
Right, I agree.
All right, anyone else? Any other questions? Motion?
Well, Mr. Secretary, given that there were a limited number of people who didn't provide any address at all, I would move that we send a letter of instruction to Stewart County and Election Supervisor Diane Howell and Deputy Registrar Mary Ann Miller.
All right, we got a motion. Do we have a second?
Second.
I've got a motion and a second. All in favor signify by saying aye.
Aye.
All opposed, same sign. That motion carries. Thank you, Mr. Coleman, for being
Thank
here.
you.
I would just make sure that they're getting things in order where we don't see you again on this issue.
I hope not, thank you, sir.
Mr. Harvey.
Yes, sir.
The, Miss Iverson,
Yes, sir.
the unlawful possession, we still have that out there, correct?
Yes, sir. She went and picked up two completed absentee ballots from friends of hers to deliver for them. So she was in illegal possession of 2 absentee ballots.
When you say deliver, she actually just mailed them, right?
Mailed or delivered them to the elections office, yes, sir.
She actually, the investigative report says she delivered them to the post
To the
office.
post office. So would that be consistent, based on what you had said earlier?
In the past, it's been a violation, correct?
Correct.
But you don't believe it's a violation now?
Well,
Or you're gonna present a,
I am going to present this issue at a future state election board meeting.
We want, I mean, however that issue resolved will determine the outcome of this case.
Correct. Since I,
well, I would be very careful that we can't act on what may or may not happen in the future. I think it's very unfair for us to.
well, that's true, we may reject Mr. Bullock's.
right, and
Well,
that's,
and the legislature may as well.
I was gonna move to bind it over.
I'm just saying, I think we gotta, I know we've had some conflicting things going on today, but, I mean, this is, when somebody is taking these ballots to mail them for somebody else, whether they're doing it maliciously or not, it's still, it's no different than the person that we bound over that was carrying 50 to the post office. So I think I think we need to continue to be consistent when we can. All right, I'm sorry, Mr. Simpson.
Move to bind that case over.
All right, we've got a motion and a second to bind over. Any other discussion? Hearing none, all in favor signify by saying aye.
Aye.
All opposed, same sign, and we have bound Ms. Iverson over to the AG's office. All right, that's got us on that, correct, Mr. Harvey?
Correct, yes, sir.
Moving to,
City of Valdosta.
2013, number 16, City of Valdosta.
This is a case that was submitted, self-reported by Deb Cox, the election supervisor in Miles County. It involves an election in 2011, the City of Valdosta election, in which there was a single precinct where the poll manager at that precinct allowed 118 county residents to vote in the city election. There were some voter certificates that had alterations where somebody had either checked am a city resident or am not a city resident, and that had been crossed out. There were 5 voter certificates for voters who did not appear on the list of electors, and there were 16 voters who appeared to have voted without completing voter certificates. So there was clearly a breakdown at this one precinct, precinct number 8. Ms. Cox responded by firing the staff that worked there, training the remaining staff on the importance of requiring only qualified voters to vote. It's an event that happened in 2011, And based on the response of Ms. Cox and the corrective action taken, I think this is another one that might be best resolved with a letter of instruction.
We received the original complaint from Ms. Cox, correct?
We did. She self-reported.
Self-reported.
Yes, sir.
Okay, any questions for Mr. Harvey? Anyone else wish to speak? Ms. Cox? Welcome. Thank you for your patience.
Thank you, sir. Deb Cox, 318 Crestview Drive, Valdosta, Georgia, 31602, and I'm the Supervisor of Elections for Lowndes County. I would respectfully like to disagree with the letter of instruction. I feel like we did everything in our power to train our poll workers both before and after. We didn't have to change anything, and this was an unusual event. You have this in front of you, I hope. This is what I turned in. And I'm just going to highlight a few things in there to show what we did to prevent this happening long before it did happen. Document 1 is a copy of the letter of appointment for the poll manager, as is appropriate. Document 2 is a list of the poll manager's experience prior to November 2011. She worked since 2006, both municipal and county elections, without incident. So that's never occurred before, and she's had the exact same situation. Documents 3 through 6 are copies of certificates of training for all the poll workers, as is appropriate. Document 6.1, which I did not submit previously, and I have if you want it, is a sign-in sheet when they came to training. Okay? Our training is about 6 hours, sometimes more. We'll do 3 hours for book training and then 3 hours of practical as a minimum. So what we teach them, or what they learn online from the book, they have to come into our office and demonstrate that they know what to do, not just take it for their word. Okay? Document 6.2, which you don't have either, shows training payroll where we paid her and her poll workers for training, so it's established that they were there. The next few documents show part of what we covered in training. Most of what we teach in training, we give them as a handout to take home and refresh on before the election. We also have all of those handouts in the poll manager's notebook for review on election day if there's any question. They also have a phone number available, including my cell, if they can't get through to the office, if they have any questions. And we have board members rotating through the precincts all day long. So if there's a question, there's somebody there at least every other hour. Documents 9 and 10 are the notes I use to teach poll worker training. Item 15 and 24 both reference no county voters for this election. Note to myself, which you'll see down there as well, says repeat ad nauseum until I'm sure the poll workers get it. I did. I repeated that until I couldn't stand it anymore. Document 11 is a cheat sheet where we gave them special instructions for that referendum. It was a school consolidation referendum, and only city voters were allowed to vote to give up their charter. It addressed residency requirements, gave possible scenarios on how to handle each one. The note at the bottom of the page said, under no circumstances will county voters be able to vote on the school consolidation referendum. Call if you have any questions. So that's another place it was. Again, this handout was both used in the classroom, given to the poll workers to take home and review, and in the poll manager's notebook for review on election day. Document 12 is a copy of the supplemental list used for training with notes at the bottom about how to handle special situations. County voters are not listed as one of the available options. Document 14 is a copy of the voter certificate table training. Again, this was used to train the poll workers, given to them to take home, put in the poll manager's notebook. And number 7 on the training says, county residents don't vote. Document 15, again, training and everything, is the training and handout for county residents with information about why they can't vote on the school consolidation referendum. This is what the poll workers were supposed to give them when they came in and wanted to vote, to explain why they couldn't vote in that situation. Document 16 is a copy of the affidavit of residency for city residents. Again, training, handout, and all that. Document 16 is express poll training notes and practical training directions, again, referencing no county voters. The previously referenced items were not the only items the poll workers were trained on. They were trained on everything, but I'm just talking about those in specific. They take a test. They have to pass our test at 90%. If they don't pass it at 90%, they're scheduled to retrain. If they choose not to retrain, they don't work. Anything that they miss between 90 and 99%, we go over with them immediately to make sure they understand it. All the training materials are kept on file for each poll worker and each precinct for 4 years until we reach that election again in the cycle, just so we can look back and see what happened 4 years ago. All of these measures ensure that all poll workers deployed on election day in Lowndes County are well trained, are confident in their ability to conduct an election, and that there's no question in our minds about the poll worker qualifications or their ability to do the job correctly. These were not new poll workers or a new manager. City counter voter exclusion elections were not new. They've done that before. All previous elections had been handled correctly. None of the other polling places made the same mistakes before or after that incident occurred. The Board of Election did everything possible, going well above and beyond minimum training requirements for poll workers to ensure they were trained and knew their jobs. All the training was documented, and there was literally nothing else we could do to ensure the poll workers did their job correctly. For these reasons, I feel like we should not be held responsible for the poll manager permitting the unqualified voters to vote and willful omissions by the poll officers. We did our job to the best of our ability to ensure fair and accurate elections. In this case, the responsibility lies solely on the poll manager. And that's all I have.
Very good. Thank you for that.
Thank
Any
you, sir.
questions for Ms. Cox?
I had a question, Ms. Cox, just out of curiosity. Did those 118 votes make a difference could they have made a difference in the election?
It was a landslide election. It made no difference whatsoever.
What's the explanation for doing it? Because letting people vote that they know shouldn't vote.
I can't account for motive, since I wasn't there and I'm not that person, but it was a very contentious election. It was a very hot button issue. Emotions ran high on this one. I don't know if you've paid the attention to football, but that's all there is in Lowndes County. You know, it's Valdosta football Wildcats. Everybody's heard about them. And the issue was whether they wanted to give up their team or not. And it was hot on both sides. County residents did not want the city residents there. The city residents didn't want to go.
That seems like to me that's when you gotta be the most careful.
Right, exactly.
Do you know the names of the poll workers that actually allow the people to vote?
We have the names of the poll workers in the polling place. One of the statements given by one of the assistant managers said that she spoke with the poll manager, told her that was incorrect, that what she was doing should not be happening, and she was told to sit down and shut up and go sit in the corner.
By the poll worker?
By the manager.
Poll manager.
Right, told the assistant
That
that.
is this,
Ms. Williams.
Yes.
Lee Williams?
Yes.
And did Ms. Williams, did Ms. Williams offer any explanation as to why she allowed this to go on?
No explanation whatsoever. She was very difficult to talk to, if at all. She didn't want to respond to any inquiries. The poll workers were very forthcoming in what they had to say. She was not. The paperwork coming back for the first time ever was in such disarray it took us days to figure it out. As a matter of fact, our certification ran late because of that. But we had to get to the bottom of it before we figured out how many votes were actually cast. But it's never been in that disarray before.
Mr. Worthing, just for the record, we did interview Ms. Williams, and she said that she must have misunderstood the instructions, and she's deeply sorry. That was her explanation.
Do you believe she misunderstood, Ms. Cox?
No, sir.
I didn't think you would. I thought you were going to answer that way. All right, thank you very much.
Wildcat fan?
I'm not a football fan, by the way.
All right, thank you very much.
Thank you, sir.
Anyone else wishing to speak on this matter? All right, anything else for Mr. Harvey?
No, sir.
I move that we dismiss the case against the Board of Elections and Ms. Cox in
motion and a second. Any other discussion? Hearing none, all in favor signify by saying aye.
Aye.
All opposed, same sign. That motion carries. Let the record show that Ms. Sullivan's now back with us. All right, Mr. Harvey.
Mr. Secretary, Max, may we take a 3-minute break?
Absolutely.
5-minute break? Just to-
Let's take a 5-minute break.